New filing today brought by the Manhattan DA Alvin Bragg in his case against Donald Trump for the Stormy Daniels hush money payment. Don't forget, that's the first indictment of Donald Trump, right? Where he paid a porn star through his fixer lawyer at the time, Michael Cohen. And then while he was president of the United States in the Oval Office on at least 17 occasions, wrote checks out to Michael Cohen under the guise that they were for legal services when they weren't. They were to reimburse him and pad the books a little bit to give him more income because he paid off the porn star before he was elected, and to try and quash that story to get him into office. So that case is going along and moving along nicely. It's set for trial in March of 2024 before the Honorable Judge Juan Merchan in the New York court, the New York State courthouse, a judge that I've been before many times. He's an excellent judge. And in that case, there has recently been a new filing. And this was a letter that was written by Susan Hoffinger, who's one of the lawyers on the case, one of the prosecutors on the case. She's also an executive assistant DA at the Manhattan DA's office and the chief of the investigation division. So she's pretty high up there, and she's supervising this case and probably going to also try this case. She also successfully tried the 17-count conviction case against the Trump Organization, the one where Alan Weisselberg testified. That was last year. So she wrote a letter to Judge Lewis Kaplan, who is in the Southern District. Now that's a federal court. That's a whole other court. And that's the judge and the court that heard the case and E. Jean Carroll versus Donald Trump, the civil case, okay, not to be confused with criminal. And so let's for a minute just pause. There's two different cases, two different courts, and two different standards in Manhattan. One is this defamation case, E. Jean Carroll versus Trump. There are two of those cases. One already went to trial where he was convicted, or where he was found liable for defaming E. Jean Carroll, and she was awarded $5 million, and he continued to defame her after the fact, especially when he brought a counterclaim where he said, I was vindicated because they only found me guilty of sexual abuse, not rape, because she said he raped me, because everybody knows that rape is when you forcibly insert something into somebody's body, but there's, into a woman's vagina, for the purpose, if you insert forcibly something into a woman's vagina, that's rape. And that's what she said. But New York has a kind of arcane quirk in the law that it has to be a penis for it to be rape. Otherwise, it's sexual abuse. And because they weren't sure, the jury wasn't sure whether or not, I should say, E. Jean Carroll couldn't tell the difference between Trump's finger and Trump's penis, which, that made Popak blush when we talked about it on our podcast, but they couldn't. And so as a result, it couldn't fit within that New York definition that had to be penis. And so they found him guilty of sexual abuse, not rape. But, in the lay person's term, of course it's rape. Anyway, so in that particular case that already happened, Donald Trump sat for a deposition. It was taped, it was under oath, and he was questioned. And what's happening right now in the state court case, the Stormy Daniels case, is they want access to that deposition. Why do they want access to that deposition? Because there's going to be all sorts of evidence all over that, because questions were asked of Donald Trump about how he treats women and forcibly takes, does sexual things to them. I'm sorry, I'm struggling with saying it out loud because it's so repulsive and so vile. It's so vile that he would do this, that he, like the Access Hollywood tape, for example, that really features in the Alvin Bragg case. It's part of the case because it was right before the election, how he was talking about women, how he, grabs them by, when you're famous, you can just grab them by the P word, the P word and just take what you want. And, it's so upsetting. setting. Anyway, is going to feature in the Stormy Daniels case because it's relevant to his attitude toward women around that time. And it was something that was brought up and he was questioned about in the E. Jean Carroll case. The Manhattan DA's office issued a subpoena to Roberta Kaplan, not Judge Lewis Kaplan, Roberta Kaplan, who's E. Jean Carroll's lawyer, and said, we would like to have access to that deposition. Can you please give it to us? Because if the defendant, Mr. Trump made admissions or any other relevant statements that could be considered admissions that are relevant for the Stormy Daniels case, they could be used against him at trial. And so they would like to have access to that. And so they issued a subpoena to Roberta Kaplan, and and the issue is, and when Donald Trump moved to quash that subpoena, which he can do, and this happened in front of Judge Merchan, and Judge Merchan, he said, the subpoena, by the way, there was multiple subpoenas, not just to Robbie Kaplan for the deposition. It was also to the Trump Organization for certain emails and for other information. And so Trump brought this motion to quash the subpoena, all of these different items that were listed in the subpoenas. And Judge Merchan ruled on them. He said some were overbroad, some were relevant, and, kind of made a ruling, which is very standard in these cases. But when it came to the subpoena to Robbie Kaplan for the deposition, what Judge Merchan said was, I don't find the subpoena to be overbroad, and I do find it to be relevant. Therefore, I will allow it. The people have established, the people meaning the prosecutors, that's what we call them. The people have established that this is not just a fishing expedition, that this is both relevant and material. However, he said, it's unclear whether it is under a protective order or not, because originally the deposition was put under a protective order by Judge Kaplan in that case. And Judge Merchan just was not clear whether A, it's still under a protective order, and B, whether complying with the subpoena would violate that. So what happened today is Susan Hoffinger, the chief of the investigation division and the executive assistant DA in the Manhattan DA's office under Alvin Bragg, wrote a letter to Judge Kaplan and basically said to him, please clarify. Can you please clarify whether or not we can have this information? Because Judge Merchan said this court does not wish to create any issue or conflict with Judge Kaplan's order. Therefore, the appropriate course of action is for either or both parties to seek clarification from Judge Kaplan as to whether compliance with the subpoena would in any way violate his order. If the order is still in effect, then Kaplan, Hecker, and Fink, that's the law firm, must not comply. On the other hand, if the requested materials in their entirety are no longer protected by the order, then Kaplan, Hecker, and Fink is directed to comply with the subpoena within 16 days from the date the parties receive confirmation from the Southern District. So that's what's going on in the Stormy Daniels case. It's still going, and the prosecutors are looking to get information so that they are ready to go to trial in that case in March. Don't forget that case also, that recently Donald Trump tried to move that case to federal court. If you recall, he tried to remove it because he doesn't like Juan Merchan. So he's judge shopping and said, let's go. This is a really important federal matter. So I don't think I should be prosecuted in the lowly state court. I'm sort of, paraphrasing and adding a little bit of commentary there. He didn't say it like that, but that's basically what he was saying. And so he went to federal court. He got assigned Judge Alvin Hellerstein and said, Judge Hellerstein, since I'm the former president, I should be prosecuted in federal court, not in state court. And so therefore, I'm removing this case to federal court. They had oral arguments. They briefed the matter, and Judge Hellerstein ultimately said, yes, you're a former federal official, so you qualify the first prong that would remove to federal court, but you don't qualify the next two prongs, which is there's nothing you were doing under color of federal law, under the color of your authority as a federal officer. This was entirely personal. This was a personal payment to somebody that you had an affair with, and this was your personal lawyer. This had nothing to do with your presidency, number one. And number two, there's no federal defense that was implicated here that would be appropriate. And you have to have all three to get removal to federal court. So Judge Hellerstein remanded it back to Judge Merchan. And so it's continuing in state court. And this is very standard, back and forth, issuing subpoenas, getting evidence, and asking the judge to make rulings. And so this case is moving along and moving forward nicely. And I see no reason why this won't go in March of 2024. I'm Karen Friedman-Agnifilo with Legal AF. Thank you so much for joining. Check out our new merch at the Legal AF store. And that's one way of many that you can support us. Thank you so much for joining.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.